Hey there, Wicked Title folks. It's Cheryl here, and I have with me today Jonathan Wilson from FinCEN Report Company. Jonathan, thank you so much for joining me.
Thanks for having me, Cheryl.
So, FinCEN just kind of blew up on us. I'd really love for you to give me your take on like what happened and what's going to happen next.
Sure, sure. Well, as we were talking, we've seen this movie before. It's not unusual when there's a new regulation that comes into effect, that parties that want to, participate in the process file lawsuits in federal court. And as everybody knows, there were several lawsuits filed trying to prevent the real estate rule from coming into place. There was the Fidelity case in Florida, and then there was a case called Corley that was in a federal court in Texas. In both of those cases, federal judges ruled that the real estate rule was constitutional, and they specifically looked at the reasoning that was also applied in the Flowers case. The judge in the Flowers case reached a different conclusion, and the way our court system works is that if one federal judge says this law is unconstitutional as written, the proper remedy is to issue what's called a writ of vacater, and that basically says this regulation is no longer enforceable because it's unconstitutional. And that's what happened in the Flowers case.
So let me ask you, because there have been some other cases that have come through in the last few months or so, saying that judges can't do a nationwide injunction, but this is a vacated rule. So what's the difference?
Sure. So an injunction is when the court says, you government, you should not do it this way. And the injunction issues out of a particular case because a particular plaintiff sued the government saying this rule is unconstitutional, either the way it's written or the way it's applied to me. And the bias against those sort of nationwide injunctions reflected that whatever the facts were for this particular case, they might not apply to everyone. So it was wrong for that judge to issue a nationwide ruling affecting all potential plaintiffs when only one individual plaintiff was in front of them. That's not what happened in the Flowers case. In the Flowers case, the plaintiff said this rule, as it's written, regardless of how it might be applied, is unconstitutional. And so the judge's ruling was that the right outcome was this vacator, basically saying this rule never should have issued in its current form.
Is there also a difference because this was a rule from a regulating body as opposed to a law passed by Congress?
There is a big difference, yes. In this particular case, the argument in the Flowers case was that we have the Bank Secrecy Act, right, which goes all the way back to 1970, I think, and it says that FinCEN was empowered to impose rules on financial institutions, which are defined to include title agents, that require them to report suspicious transactions. And the problem was that the statute didn't really define what a suspicious transaction was. So in its rulemaking, FinCEN said, well, these non-financed residential real estate transactions where the transferee is a non-individual, they are categorically suspicious. Therefore, we're going to require reporting about anything within that category. And the judge in the Flowers case said, no, the statute only said that you could require reporting on suspicious transactions. And I interpret the word suspicious to mean you have an affirmative reason to believe that something is going on here. Therefore, you can't require categorical reporting. Now,
Okay.
that exact same argument was heard by the other courts in the Corley and the Fidelity cases, and those judges reached the exact opposite conclusion. Unfortunately, we don't just count judges and see who wins. If any judge pulls the plug and says it's unconstitutional, it is until that ruling is heard through the appellate process. So that's the point we are in the process today.
Yeah. So what does come next?
Right. So the most likely next step would be for the government, FinCEN, acting through the Treasury Department, to file a notice of appeal. They have 30 days to do that from the date of the ruling, and that would take a appeal then to the Fifth Circuit Court of Appeals, which takes appeals out of the federal courts in Texas. And then the Fifth Circuit would have a chance to hear this. The real question is whether when they file their notice of appeal, they also ask the Fifth Circuit to stay the ruling of the lower court while the appeal processes. Uh, there are no great statistics about this, but my back of the napkin calculation is that more than 50% of the time, federal courts do stay lower court rulings in these situations, precisely because our system allows a single judge to pull the plug, pull the ripcord, if you will, on this entire reporting scheme, which obviously affects the entire real estate industry, all these participants, all the title agencies and law firms and service providers involved. So it's really disruptive to allow a single judge to reach that outcome. So in my view, the better option would be to stay the ruling until the appeal can be heard, especially since there are uh, courts in two other cases that have reached the opposite conclusion.
Okay, so the possibility we're looking at is sometime 30 days from when the rule was vacated, FinCEN could file an appeal and it could go through the entire appeal process, which potentially could take months before there's a change in what we need to do day to day. But it could happen very, very quickly after they file an appeal if a judge issues a stay on the vacated ruling. Am
That's
I
exactly right. And
understanding?
yeah, and we've seen this movie before. People who remember the Corporate Transparency Act situation, where there we had multiple lawsuits, multiple courts, contradictory injunctions pointing different ways. And at each step in the process, FinCEN was asking the appellate courts to stay the lower court ruling while the appeals ran their course. When they ran into an impasse, they actually went to the U.S. Supreme Court and got a ruling there that imposed the stay while the appeals panned out. What happened with the Corporate Transparency Act, though, was that you had the new Trump administration that really didn't believe in the Corporate Transparency Act. They had campaigned on the idea of eventually putting to bed the Corporate Transparency Act. So at the right time, they did that through their own regulatory proceedings, effectively putting the Corporate Transparency Act on ice. It's a different outcome here in the real estate rule. Although this was something that FinCEN began in 2024, the administration has, since the last inauguration, been testifying before Congress favorably regarding the real estate rule. So I think it's more likely that FinCEN is going to see the course in this case and litigate the rule to a conclusion.
Right. Okay. So FinCEN's got a history of filing appeals for these things. They do tend to fight for the rules that they try to put in place, and they've got the administration behind them. So it makes it more likely that we're going to see them follow the appeals process as far as they can take it.
That's my best guess at this point. Yes.
Okay. So if they don't file an appeal, which, is probably unlikely, but if they don't choose to go that direction, then what might happen? What are
Sure.
their other options?
Sure. Well, one thing would be they could completely drop it. I don't think that's very likely, but they could. And if they don't appeal, then this rule is not in effect, and perhaps FinCEN could issue a new rule. Uh, if they wanted to go that path, one way they could adopt a new version of the real estate rule that solved for the problem as it was described by the Flowers judge. And that is that the Bank Secrecy Act says that they can require reporting on suspicious transactions. Let them go ahead and build a deeper record as to what suspicious means.
Right.
In the briefing in the Flowers case, FinCEN said that the real estate rule worked in identifying suspicious transactions because they went back for 6 years and they looked at non-financed real estate transactions, and they found that roughly 42% of the parties involved had already been the subject of a suspicious activity report. They said, aha,
Wow, that's a big number.
42% had a suspicious activity report. Therefore, these do tend to be suspicious. Therefore, reporting is required. Now, the judge in the Flowers case wasn't persuaded by that. I am sure in our data-driven world today, with all the tools at our disposal, if I was writing briefs for FinCEN, I could come up with some other indicators of suspiciousness
Yeah,
that might supplement my findings. It wouldn't be very hard to basically reissue the rule with that supplementary finding of suspiciousness and
yeah.
then go back and say, aha, we have solved the problem. We now have this basis to believe these transactions are suspicious as a category. Therefore, this ruling now fits within the BSA framework.
I suppose they could even adjust kind of that decision making of how do we define what needs to be reported. Maybe they narrow that a little bit further based on that data that they're looking at. And that would probably satisfy that judge's requirement as well, right?
If there was a reasonable basis for doing it,
Yeah,
from what I had seen, we don't have all the data that FinCEN does. They were talking about non-financed residential real estate transactions. They weren't limited in dollar value. In fact, in the rule, they had examples that were sub $100,000. They had other examples that were over $1 million. So there wasn't really a dollar value limitation. They want this to be a nationwide rule, so they don't want to limit it to certain zip codes.
right,
But if you think about the footnotes to the original rule, they had examples in Missouri, they had examples off Long Island, New York, they had examples in South Beach, Miami.
right.
So how
Yeah,
does that
but
fit a pattern? I don't know.
right. Yeah, it really depends on what that underlying data is. If they could find any other pattern for decision making, that there's some other commonality to these things. Now, you said that it was 42% had a suspicious activity report filed on them by a bank at some point. Is there a possibility that maybe they create a database of these things that we have to search against?
Well, there is a database. It's not public though. All the SARs that get filed aren't visible to the public. So presumably FinCEN has that database of all the SARs that have ever been filed, and they could derive all kinds of conclusions from that database if they wanted to. What's actually in there, you and I don't know.
Right. But could they make that information public to be
I
searchable?
I don't think that they could do that under the Bank Secrecy Act. No.
Yeah. Yeah,
Now,
that might be too much information disclosing that, privacy issues.
and I suspect that there are provisions in the Bank Secrecy Act that prohibit the government from making that data
Yeah.
public. However, if they wanted to, and this might be ascribing a little bit too much agency to the staffers at FinCEN, they could create an anonymized version of that database, which
Yeah.
could be very educational. But that would require an awful lot of effort. And in this age of trying to do more with less, I think that's probably not too likely.
Yeah, I question that statistic, that 42%, simply because I know how easy it is to end up with a bank filing a SAR. You only have to deposit over, $9,999 at one time to
Mhm.
trigger that. There's lots of reasons that somebody very legitimately would do that. And I think they can also file a SAR if you make a couple of deposits that look like you're trying to stay underneath that $10,000 cutoff. So I I think a lot of us have probably had SARs filed a bit due to our banking activity at some point in time without us even knowing it ever happened. So yeah, I wonder, is that enough? But I guess time will tell.
Yeah, but there's a whole cottage industry of consultants out there that criticize the procedures built around SARS. Uh, Banks are constantly getting dinged by their auditors for how well they process SARS. It seems to be very inconsistent. Um, so
Yeah. Are
it's
they
interesting
missing them? Are they filing too often? And that $10,000 number, that's not tied to inflation or anything, is it? That's a hard number.
that that is a hard number, and it's been a hard
And
number for many years.
yeah, so as our economy evolves, that threshold realistically becomes lower and
Yeah,
lower.
but here's where the administration, kind of gets put on its back feet. If we had real beneficial ownership reporting of the kind contemplated by the Corporate Transparency Act, a lot of these SARs wouldn't be as necessary.
Yeah,
And the implementation of the real estate rule would be a lot more intuitive. So it's
yeah,
it's a bit of a contradiction for the administration to pursue the real estate rule when they've already effectively iced the Corporate Transparency Act.
yeah,
If I were the king of America and I wanted to have something that really made it hard for money launderers, and I could only pick one thing, I would eliminate SARS, I would eliminate real estate rule, and I would go back to the Corporate Transparency Act. But nobody voted for me, so who knows?
right, yeah, yeah. Because I mean, realistically, the filing of those FinCEN reports does not in itself say that a transaction is suspicious. It's basically just giving FinCEN a database of information so that they can go and use it for research if they have some other reason to believe there's something suspicious,
That's
right?
right. If a particular individual is under suspicion by Drug enforcement, for example, drug enforcement could go query the FinCEN database to see, is this person a beneficial owner of residential real estate? And if they find numerous transactions, aha, that's a possible indicator of money laundering. Now they can go do their investigation in that direction. That's
Yeah,
how the real estate report is intended to supplement anti-money laundering law enforcement.
right. Interesting. So, yeah, it'll be really interesting to see where all of this goes. Do you think there's a possibility that they abandon the real estate reporting rule altogether and lean harder on the anti-money laundering and the SAR reporting? Could we see title agents being required to file SARs?
You could see title agents required to file SARs. And in a sense, that's what the real estate reports were. They categorically defined non-financed residential as categorically suspicious, and they said, file these things. Uh, I suppose in theory that's possible, but it's unlikely given the resources that FinCEN has available and given the policy direction that the current administration has pointed them towards. I think they're left with this particular tool of the residential real estate report. They don't have CTA to fall back on, and so this is the only hammer they have to use, and everything is going to look like a nail.
Yeah. Well, I think I'd rather, if the choice is that they stick with some version of the real estate reporting or they require title companies to file SARs and comply like banks do with anti-money laundering, that seems like it'd be a lot bigger burden on title agents than the FinCEN real estate reporting.
It would be. I mean, that is a place where the title industry does not want to go, where they
Yeah.
have to file SARs. As much as you might dislike complying with the real estate report, it did have fairly bright lines. We all know what they were, and if the transaction fell into that category, file the report. Easy. The SARS world is very judgment driven. You have to have this risk-based assessment. No one knows what risk-based means, and you have to have all of these judgment-based outcomes and processes to link to your SARS, and then you have to test how well your people are actually applying the rules. It is a much more complicated judgment-driven compliance regime. So if
Yeah.
I was
So
a,
we
a
should be
title
careful
agent,
what
I
we
would
wish
much rather
for.
have real estate reporting.
Yeah, yeah, I think so too. So for everybody who's, cheering that, that there's been a stay for the real estate reporting, be careful what you wish for because yeah, I think it could be a lot worse. So
In this world, it's a truism to say it always could be worse.
yeah. Well, Jonathan, this has been really helpful. Is there any other, thoughts or information you want to share with us that you think it's important for title agents to know right now?
You know, we're back to where we were pre-March 1. You do not have to file real estate reports on transactions today. That could change with a moment's notice. So, keep tracking here at Wicked Title Forum. Pay attention to us at the FinCEN Report Company because as soon as there is a development, I'm sure we're both going to be talking about it, and that's how we'll alert the industry.
Absolutely. Do you think title agents should continue collecting the data that they, all these procedures they put in place to collect all this data for the reporting? Do you think they should continue doing that part?
For the time being, yes, and that seems to be the consistent judgment of everybody in the industry that spends time thinking about it. Continue to identify transactions that would be reportable. Continue to collect the information on those transactions. It's always possible that if FinCEN got a stay of the Flowers ruling, that they would say, okay, the rule is now in effect. You need to report everything that took place in the last 20 days to catch us up. I think there's a good reason why they might not do that, but I can't say it won't happen. So for
Well,
now,
and a
yes.
transaction takes such a long time, 30, 60, 90 days to do a transaction. So, if you're starting to collect information on day one of a transaction and 60 days later you're getting to closing and, on day 55 they put the rule back in place. If you weren't collecting that information from day one, that could really leave you scrambling, even if they're not making it retroactive.
That's exactly right. It would not be impossible, for example, for FinCEN to file their notice of appeal, in the next week or two. brief the Fifth Circuit a week or two after that and ask for an emergency hearing on a stay. Get that issued at the end of April, and FinCEN says, okay, May 1, we turn it back on again.
Yeah.
And if you started your transaction in early April and you're going to close May 15, now the rule applies again. And you're
Yeah.
going to have some disruption with your customers if you hadn't been collecting that data all along.
And is your company still, are the doors still open? Can people still use your service to collect all that data and then just not actually file the report?
Yes, we are still open. We're still accepting orders. We get orders every day. We're even finding that some people are continuing to file, even though they don't have to, just because they've already built the system. We filed several reports this morning, and we're recording this on, March the 31st. We tell customers they don't have to, but a lot of them find it easier just to go ahead and go through the motions because they've already built the system to comply,
Well,
and
that's really interesting to know that some
okay to
people are
do.
still filing.
That's right.
Yeah. Um, and just for clarity, you are at fincenreportcompany.com. Is that correct?
That's right. FinCENReportCompany.com. You
Because
can also find
there
the
are some
filing
very
engine at.
similar names out there. We don't want to confuse you with anybody else. So,
That's right.
if you do need help collecting that information and getting, reasonable reliance certificates signed, then fincenreportcompany.com. Jonathan and his team are standing by to
Cheryl, hang
help.
on. You added one there. FinCENReport.com. Sorry if I misspoke
FinCEN,
earlier. Yep.
FinCENreport.com. Yes, and I should know this. I go to your website all the time.
FinCENReport.com.
FinCENreport.com. They're standing by to help if you need help collecting the data and getting the reasonable reliance. And your system also helps to vet the transaction, doesn't it?
That's right. For a very small fee, there's a questionnaire that you can fill out that will ask you all the questions, and we will give you a reportable versus non-reportable outcome. And if it's not reportable, we'll actually promise to pay the first $10,000 of your legal fees to defend that action if there was ever a regulatory enforcement built around that decision.
Fantastic. All right. Well, thank you so much for being with me today and answering all of my questions. This was so helpful.
Thank you, Cheryl.